Welcome to our online live lecture session of Swayam Prabha channel. I am Riya Praman. So we are learning BPSC 132, that is Indian Government and Politics. We have started with this course. Uh, have already taken 3 sessions on this course. So we will be talking about Block 3 institutions, and we will be covering Unit 7 legislature and half part of Unit 8, that is executive. So it is very important to understand our parliamentary system, and for that I have prepared this flow chart which will help you. So the Indian parliamentary system has an executive branch and a legislature. So the legislature is a bicameral legislature. That means there are two houses which comprised of Rajya Sabha and Lok Sabha. So this Indian parliamentary system owes origin to the Westminster system. So from there onwards, we follow that Westminster model, and in this the legislature is comprised of Rajya Sabha and Lok Sabha. Whereas if we talk about the executive branch comprises of the Prime Minister, cabinet ministers, and the administrative machinery in which there are bureaucrats and civil servants. So this executive, which comprises the Prime Minister, cabinet minister, and the administrative branch, is called as the government. So the government is accountable to the Lok Sabha, and you should always remember that in a parliamentary system, the legislature and executive are not separate. They are not separate from each other, they work together. Whereas in a presidential form of government, the executive and the legislature work separately. So the Lok Sabha could initiate no confidence against the government. The Lok Sabha has that power. Now, if we talk about the parliamentary system, there is a president, even though it's a parliamentary form of government, but we have both president and prime minister. So the president is called as the head of the state, whereas the government is headed by the prime minister, which comprises of the cabinet ministers and the administrative machinery. So let's move forward, and we will be understanding all these things in detail in our session. So let's start with our Unit 7, that is legislature. To introduce this legislature, let's start with this. The term legislature has been derived from the Latin word lex, which means a distinct kind of legal rule, mainly of general application. So, if we want to know the origin of this word legislature, we can see that it comes from a Latin word, that is lex, which means a distinct kind of legal rule, mainly of general application. So this rule is named legislation, and the institution which enacts it on behalf of the people is known as legislature. So this is the rule which we are talking about is called legislation, and the people on behalf of every citizens who works that or who enacts these legislations is known as legislature. So essentially, there are two models of legislative structure, the parliamentary and the presidential, as I have already briefly told you about this in the previous slide. So in a parliamentary model, the executive is selected by the legislature from among its own members. Therefore, the executive is responsible to the legislature. So in a country where there is parliamentary form of government, it is the legislature who select the executive among its members, from among its own members, and therefore the executive is responsible to the legislature because it is the legislature only who selected the executive. Now let's talk about the presidential system. The presidential system is based on the theory of separation of powers and does not permit any person to serve simultaneously in both executive and legislature. So this is one of the most important feature of presidential form of government, where if a person is a member of the executive, he or she cannot become a member of the legislature, and if a person is a part of legislature, he or she cannot become the part of the executive. So there is separation of powers. They work differently, they work separately. There is no connection between executive and the legislature. But in a country where there is parliamentary form of government, there the executive and legislature works together. They are not separate from each other. So this is the basic difference between the parliamentary form of government and the presidential form of government. So, for example, we can say that India has parliamentary form of government, whereas America has presidential form of government, where the head of the government is the president. Whereas in India, the head of the government is prime minister, whereas the head of the state is president. So, let's talk about the union legislature. Under the provision of Article 79, the Parliament of India consists of the President and the two houses, the lower house or Lok Sabha, which is also known as House of People, and the upper house or Rajya Sabha, which is known as Council of States. So, to understand this parliamentary form of government and to understand the union legislature, we should understand that it comprises of president plus two houses. And what are these two houses? We have Lok Sabha. In Hindi term, we call it as Lok Sabha, which is known as lower house and house of people. Whereas we talk about upper house, in Hindi, we use the word Rajya Sabha for it, which is the Council of States. So, while the Lok Sabha is subject to dissolution, the Rajya Sabha is a permanent chamber which cannot be dissolved. So, there is a difference between the Lok Sabha, the functioning of Lok Sabha and Rajya Sabha. We can say that Lok Sabha can be dissolved anytime, but Rajya Sabha is a permanent chamber which cannot be dissolved in any circumstances. Also, to know about the president, we should understand that the office of the president also never remains vacant. So, the president's office never remains vacant, and these three structures, like president, the upper house, and the lower house, comprises the union legislature. So, let's start talking about the president. The president of India is an integral part of the Indian parliament. However, he cannot sit and participate in the deliberations in any of the two houses. So, although the president never sits in any house of the Union Parliament, but he or she plays a very integral role in the Indian parliamentary system. The President of India performs certain important role vis-a-vis the Parliament. So there are few roles which the President has to do. So the President summons and prorogues the House from one session to another and has the power to dissolve the Lok Sabha. As we talked about the dissolution of Lok Sabha in our previous slide, so the power remains with the President, who can dissolve Lok Sabha. So a bill cannot become a law without the president's assent, even though the bill may be passed by both the houses. So suppose there is a bill which is passed by both Lok Sabha and Rajya Sabha, but that bill cannot become an act or a law if it is not signed by the president. So the signatures of presidents is very important for a bill to become a law. So a bill which cannot become a law without president's assent. The president also has the power to promulgate ordinances when both the houses are not in session. So this power also lies with the president. These ordinances, though temporary in nature, have the same force and power as a law passed by the parliament. So president also plays a very important role, and he has some very essential functions to perform. Now let's talk about Lok Sabha. The lower house or the house of people is popularly known as Lok Sabha. So for house it's called Sabha and people Lok. So Lok Sabha, which is the Hindi term for house of people, it is also known as the lower house. People of the country directly elect members of the lower house. So whenever we vote for in a Lok Sabha elections, we directly elect the members of the lower house, or we often used to call them as members of the parliament, MPs. So it includes not more than 530 members chosen by direct election from territorial constituencies in the states, and not more than 20 members to represent the union territories. So from states, there should be 530 members, and there should not be more than 20 members representing the union territories. The distribution of seats among the states is based on the principle of territorial representation. By territorial representation, here they mean to say that in a country like India, which is a very huge and vast country, not all states have the same territory of its own. So each and every state has their own territory. Someone has larger, and some states have very few area in their state. So in that case, this distribution of seats is based on the territorial representation. That means if a state is big, or if a state has large territory, in that case, many members from that territory or that state will be sitting in the parliament. Whereas if a state is small, few members from the state will represent in the lower house. So the distribution of seats among the states is based on the principle of territorial representation, which means each state is allotted seats on the basis of its population. So, large state means more population, and small states less population. So, to represent the large population, there should be more seats in the parliament, and on this basis, the seats are given or allotted. So, the state is allotted seats on the basis of its population in proportion to the total population of all the states. So, the members of the Lok Sabha are elected on the basis of the adult franchise. So, we have talked about adult franchise, and I will be telling you in brief what is about. So, since independence, the Indian citizens were given adult franchise. That means universal adult franchise. That means for each and everyone, irrespective of their gender, their class, their caste, their religion, their geographical location, they will be given voting rights, and all the voting rights are of same value. So if a person living in South India is, if his or her vote values for one, so anyone living in the northeast India will also have the same value of his or her vote. So it is about universal adult franchise where each and everyone adult. So here we should also understand that after a certain age, so for India it is the age of 18. From 18 years of age, each and every person, irrespective of their economical, geographical, or educational background, they will be given the right of voting. So these voting rights are used to elect the members of the Lok Sabha. The candidate who receives the largest number of votes gets elected. So a person or a candidate who is getting more votes from the people, he or she will be elected. So the tenure of the Lok Sabha is 5 years. So if once elected, the Lok Sabha will continue till 5 years. But also remember that it can be dissolved earlier by the president. So if president wants, he or she can dissolve the Lok Sabha before the completion of its tenure. So this is something which doesn't make Lok Sabha a permanent chamber, whereas the Rajya Sabha is a permanent chamber which cannot be dissolved. So, to be a member of the Lok Sabha, a person should be the citizen of India and must have completed 25 years of age. So, for to become a member of Lok Sabha, a person must be a citizen of India, and the minimum age to contest the Lok Sabha elections is 25 years. So, a candidate is free to contest from any parliamentary constituencies of any states in India. So, if you are a citizen of India, you can contest elections from any part of India. It is not bound to you that you will be only participating and you can only stand for elections from your own state. No, there is no provisions like this. The constitution allows us to contest elections from any parliamentary constituency of any states in India. A person cannot be a member of both houses of the parliament. So here is also one of the rule which is prescribed in our constitution, that a person cannot be a member of both the houses of parliament. So what are the both houses? Lok Sabha and Rajya Sabha. So On the same time, simultaneously, a person cannot belong to a both houses. A candidate may contest from several seats. So it is also very important to understand that a candidate is allowed to contest from several seats across India. However, he or she can have only one seat according to his or her choice, despite being elected from more than one seat. So, suppose a person is standing for elections or contesting elections from UP and from Bihar. These are the two states he is contesting elections from both the state seats. In that case, if he wins both the in both places, he has to choose only one. So, despite being elected from more than one seat, one person can only have one seat. So, a member should not hold any office of profit under the central or state government except those that are exempted by a law of parliament. So, here is also one of the criteria for the people who want to contest the Lok Sabha elections, and should not have been declared as an insolvent or of unsound mind by a competent court. So a person should not be of unsound mind. So this is also a criteria to contest the Lok Sabha elections. Now let's talk about Rajya Sabha. The Rajya Sabha or the Council of States. Rajya Sabha is also known as Council of States or Upper House. So these are all the terms simultaneously used by us in respect of Rajya Sabha. So the Rajya Sabha or the Council of State is the House of Representatives of the states. A member of Rajya Sabha has a 6-year term. So always remember that the Lok Sabha's tenure is for 5 years, whereas Rajya Sabha has a 6-year term. There is a difference here. So it consists of not more than 250 members, out of which 12 members are nominated by the president from amongst persons having special knowledge or practical experience in literature, science, art, and social service. So in Rajya Sabha, there are 250 members, out of which 12 members are nominated by the president. And who are these nominated persons? Who have a special knowledge, or who are serving the country, or who are having practical experience in literature, science, art, and social service. So president can nominate 12 members in the Rajya Sabha. So the remaining members apart from these 12 nominated members are elected by the members of the state legislative assemblies on the basis of population of the state. So the remaining members of Rajya Sabha are elected by the members of the state legislative assemblies. Rajya Sabha adopts the method of indirect election. As we learned that in Lok Sabha, we use direct elections to choose or to elect our member of the parliament for Lok Sabha, whereas the Rajya Sabha adopts the method of indirect election. There is no uniformity in the members of representatives of the Council of States. It largely depends on the population of the state. So, if we talk about Uttar Pradesh, it's a very large state, so there are many members who represent Uttar Pradesh into the Rajya Sabha. Whereas the northeastern states are very small in their territorial area. So, from there, very few people represents the state in the Rajya Sabha. Rajya Sabha is a continuing chamber as it is a permanent body, not subject to dissolution. Because Rajya Sabha cannot be dissolved, it's a permanent chamber, so also it is a continuing chamber. One third of its members retire at the end of every 2 years. So, this is Rajya Sabha. Let's talk about the special powers of Rajya Sabha. Rajya Sabha has some special powers. Let's talk about that. It has every right to seek information on all matters which are exclusively in the domain of Lok Sabha. So the Rajya Sabha has a special power to seek information in all matters which are exclusively in the domain of Lok Sabha. So this is a special powers allotted to Rajya Sabha. Also, it has no power to pass a vote of confidence in the Council of Ministers. It does not have much influence on the matters of the money bill. So, In matters of money bills, it is the Lok Sabha which influence it or which talks about it or which discuss about it. Rajya Sabha has not that much influence on the matters of the money bill. Rajya Sabha enjoys two exclusive powers which are of considerable importance. So let's see what are these two exclusive powers. So under Article 249, the Rajya Sabha has power to pass a resolution by a majority of not less than two-thirds of members present and voting, declaring that it is necessary or expedient in the national interest. So Article 249 talks about exclusive power of Rajya Sabha, where it has the power to pass a resolution by a majority which is of necessary or expedient in the national interest. Let's talk about Article 312, the second exclusive powers which belongs to Rajya Sabha. It provides special power to the Rajya Sabha to pass a resolution on another matter, that is to create one or more All India services. These special provisions make the Rajya Sabha an important component of Indian legislature rather than just being an ornamental body. So it feels like Rajya Sabha has no that much role to play in Indian politics, but we should understand that Rajya Sabha has few special powers which makes it an important component of the Indian legislature and not only an ornamental body. Its compact composition and permanent character provide continuity and stability in the system. So, because Rajya Sabha is a non-dissolved, like it cannot be dissolved, so it provides a continuity and stability in the system. Now, let's talk about the presiding officers in these two houses. Let's start with the Speaker. The position of the Speaker of the Lok Sabha is more or less similar to the Speaker of the English House of Commons. So it is somewhat like same. In English House Commons, there is also Speaker, and the role and the functions played by the Speaker over there is also similar to Indian Speaker of the Lok Sabha. So the office of the Speaker is a symbol of high dignity and authority. Once elected to the office, the Speaker does not have affiliation to any party but works in an impartial manner. So it is believed, it is a it is in constitution that once elected or once holding the office of the speaker should be neutral. He or she does not have any affiliation to any party. He can't support any party or he can't be partial about that. His or her duty is to be done impartially. So he or she acts as the guardian of the rights and privileges of the members. The speaker has the power to ensure an orderly and efficient conduct of the proceedings of the house. So the speaker is responsible to ensure that there is order maintained in the house and there should be efficient conduct by the members in the house. So the speaker's decision is final in all such matters. So the speaker certifies whether a bill is moneyable or not. It's a very important function which a speaker plays. That is, he or she certifies whether a bill is moneyable or not, and he or she also authenticates that the house has passed the bill before it is presented to the other house. So before moving the bill to the other house, it is speaker's duty to certifies it or to authenticates it that it has been passed by the Lok Sabha. The speaker, in consultation with the leader of the house, determines the order of business. He or she also decides on the acceptability of questions, motions, and resolutions. The speaker does not have vote in the first instance. For example, if there is voting going on in Lok Sabha, he or she, the speaker, does not have vote in the first instance. But if there is a tie, the vote of speaker becomes important because he will be his vote will be the tie-breaking vote. So the speaker does not have vote in the first instance, but can exercise the casting vote in case of a tie. He or she appoints the chairpersons of all the committees of the House and exercise control over the secretarial staff of the House. Also, the salary and allowances are charged to the Consolidated Fund of India. So, it is very important to know this fact that the Speaker's salary and allowances are charged to the Consolidated Fund of India. A special feature of the Speaker's office is that even when the House is dissolved, the Speaker does not vacate his or her office. He or she continues in office till the new House elects a new Speaker. So, in case there is the President declares that for the Lok Sabha House to dissolve, in that case, the Speaker does not vacate his or her position until the new House elects a new Speaker. So, this is a very special feature of the Speaker's office. Now, let's talk about the chairperson of the Rajya Sabha. The Vice President of India is the ex officio chairperson of the Rajya Sabha. So, the chairperson of Rajya Sabha is the Vice President of India. But during the period when the Vice President discharged the functions of the President, he or she does not perform the duties as a presiding officer of the Rajya Sabha. So, in case a President vacates the seat or there is the president's seat is vacant, in that case it is the duty of the vice president to discharge the function of the president. At that time, in that certain the circumstances, the vice president will not perform the duties as a presiding officer of the Rajya Sabha. The vice president is elected by the members of both the houses of the parliament assembled at a joint meeting. So how is vice president elected? He or she is elected by the members of both the houses of the parliament assembled at a joint meeting. It is in accordance with the system of proportional representation by means of single transferable vote, and the voting at such election is by secret ballot. So, in the votings of vice president, it is done by the secret ballot. The vice president is not a member of either house of parliament or a house of the legislature of any state. Also, the Vice President of India holds office for a term of 5 years. So, the tenure of Vice President is of 5 years. Now, let's talk about the legislative procedure, how and the legislative procedure moves. So, the law making is the primary function of the legislature. The first stage, let's talk about the first stage, what happens and what next stages come, we will be learning now. So, the first stage of legislation is the introduction of a bill which embodies the proposed law and is accompanied by the statement of objects and reason. So, this is the first stage. The introduction of the bill is also called the first reading of the bill. There are two types of bill, ordinary bills and money bills. So, every bill that is introduced in the house has to be published in the gazette. If the house is in favor of the introduction of the bill, then it goes to the next stage. So whenever a bill is introduced in a house, so it should move to the next stage when that particular house favors the bill. In the second stage, there are four alternative courses. So after its introduction, a bill may be taken into consideration. So in the next stage, there are four alternatives which we will be learning now. So after its introduction in one house, a bill may be taken into consideration. Secondly, it may be referred to a select committee of the house. Third, what can happen? It may be referred to a joint committee of both the houses. And fourth, there is an alternative course that it may be circulated for the purpose of soliciting public opinion. So there are four alternative courses which can happen when the bill moves to the second stage. So while the first three options in the second stage are generally adopted in the case of routine legislation, the last option is resorted to only when the proposed legislation is likely to arouse public controversy and agitation. So if a bill, if it believes that it will create controversy and agitation among the public, so in that case, it may be circulated for the purpose of soliciting public opinion. In the third stage, the member in charge moves that the bill be passed. At the third reading, the progress of the bill is quick as normally only verbal and purely formal amendments are moved and discussion is very brief. So once all the amendments are disposed, the bill is finally passed in the house where it was introduced. Thereafter, it is transmitted to the other house for its consideration. When the bill comes up for consideration of the other house, it has to undergo all the stages which it has undergone in the house where it was originally introduced. So, whatever have done in the first house where the bill was introduced, that should be repeated in the uh, another house also, all the stages from start to end. So there are three options before this house. First, it may finally pass the bill as sent by the originating house. Second, it may reject the bill altogether or amend it and return to the originating house. And third, it may not take any action on the bill, and if more than 6 months passes after the date of receipt of the bill, it is considered as rejection. So these are three things or options which can happen with a bill, which comes to the next house. So, a bill that is finally passed by both the houses is presented with the signature of the Speaker to the President for his assent. So, now the bill is moving towards the President. If the President give assent, the bill becomes an act. So, before it goes to the President or before he accepts it, the act or the law is known as bill only. After president gives his assent, his or her assent on that bill, it becomes an act and is placed in the statute book. If the president withholds his assent, there is an end to the bill. So, if a president withholds his assent, the bill will end. The president may also return the bill for the reconsideration of the houses with a message requesting them to reconsider. Sometimes it happens that the president doesn't like a bill and wanted some modifications and changes in that. So he returned the bill with reconsideration for the reconsideration of the houses with a message which requests them to reconsider the bill. If, however, the houses pass the bill again with or without amendments and the bill is presented to the president for his assent, for the second time, the president has no power to withhold his assent. So, thus, the lawmaking is a long, cumbersome, and time consuming process, as we can see how these bills are turned to be an act or a law in such a cumbersome process. It becomes difficult to pass a bill within a short time. Proper drafting of the bill saves time and skillful soliciting of opposition support makes the task easier. So it takes a very long time to for a bill to become an act. So it becomes difficult to pass a bill within a very short time. Now, let's talk about money bills. What are money bills? So, finance bill may be said to be any bill which relates to revenue and expenditure, but the finance bill is not a money bill. So, there is a difference between finance bill and money bill. Article 110 states that no bill is a money bill unless it is certified by the Speaker of the Lok Sabha. Here's we can see that how the Speaker of Lok Sabha's role becomes important because he or she is the one who will certify whether a bill is money bill or not. Once a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha. So, the money bill is introduced in the Lok Sabha, and after the money bill is passed by the Lok Sabha, it moves to the Rajya Sabha. So, the Rajya Sabha cannot reject a money bill. Rajya Sabha doesn't have power over it, so it cannot reject a money bill. It must, within a period of 14 days from the date of receipt of the bill, return the bill to the Lok Sabha, which may thereupon either accept or reject all or any of the recommendations. So, Rajya Sabha can make recommendations and it depends on the Lok Sabha whether it accepts it or not. So, within 14 days, the Rajya Sabha should return the money bill to the Lok Sabha. If a money bill passed by the Lok Sabha and transmitted to the Rajya Sabha for its recommendation is not returned to it within 14 days, it is being deemed to have been passed by both the houses at the expiry of the said period in the original form. So, if the bill is not returned to the Lok Sabha within 14 days, what it is believed that it has been passed by both the houses at the expiry of the said period in the original form. So let's talk about some parliamentary privileges. So the parliamentary privileges are certain rights which assure free and efficient functioning of the members of the parliament. So all the members of the parliament has some kind of privileges which is known as parliamentary privilege, and why these rights are given to them, it will ensure and assure free and efficient functioning of the members of the parliament. So there are two types of privileges for the members of the parliament: enumerated and unenumerated. So these two types of privileges are there. The enumerated privileges are freedom of speech in each house of the parliament, immunity from proceedings in any court in respect of saying anything or any vote case, immunity of liability in respect of publication by or under the authority of either house of the parliament of any report, paper, votes or proceedings. Fourth is freedom from arrest in civil cases for duration of the session for a period of 40 days before and after the session. And the fifth, enumerated privileges, exemption from attending as a witness in a court. So these are the enumerated privileges which are provided to the members of the parliament. The unremunerated privileges empowered the Indian parliament to punish a person, whether a member or a non-member, in the case of contempt of parliament. So these are the privileges, two types of privileges provided to the members of the parliament. So, parliamentary devices to control the executive. There are few devices which can control executive. So, one of the important functions of the parliament is to control the executive. A number of mechanisms are available to it for this purpose. So, there are few functions which the legislature plays or the parliament plays to control the executive. So the rules of procedure and conduct of business in parliament provide that unless the presiding officers are otherwise direct, every sitting begins with the question hour, which is available for asking and answering questions. Asking question is an inherent parliamentary right. So if you are in a parliament, so it is your right to ask questions, because after deliberations, after debates only, the legislation become a law. So asking question in an inherent parliamentary right of all the members, irrespective of their party affiliation. So whether you belong to the majority party or a minority party, or a regional party or a national party, it doesn't mean that you don't have right to speak. Irrespective of your party affiliations, a person, if sitting in the parliament as member of parliament, he or she has an inherent parliamentary right to ask questions. The real object of the member is asking the question is to point out the shortcomings of the administration, to ascertain the thinking of the government in formulating its policy, and where the policy already exists in making suitable modifications in that policy. Members can, with the prior permission of the parliament, call the attention of a minister to any matter of public importance and request the minister to make a statement on the subject. The minister may either make a brief statement immediately or may ask for time to make the statement at a later hour or date. So these are the things which is allowed to a parliamentarian. The adjournment motion is intended to draw the attention of the House to a recent matter of urgent public importance having serious consequences for the country, and regarding which a motion or a resolution in the proper notice will be too late. So, the adjournment motion is an extraordinary procedure which, if admitted, leads to setting aside the normal business of the House for discussing a definite matter of public importance. So, whether the House is discussing a normal routine things in the House, but adjournment motion allows it to draw the attention of the members of the House towards a recent matter or a public importance or a news or a happenings happens in our society. So it is something extraordinary procedure. The adoption of an adjournment motion amounts to the censure of the government. Besides these devices, the parliament exercises control over the executive through various house committees. So there are various house committees which also exercises control over the executive. It is difficult for Parliament to undertake thorough scrutiny of details of the functioning of the executive on daily basis. Parliament has solved this problem by establishing a series of committees. There are a series of committees which works on that. So these committees have necessary powers to scrutinize the working of the different departments of the government. So among the important committees which scrutinize the government's works, particularly in the area of public finances, two committees need special mention. The one is Public Accounts Committee and the Estimates Committee, which see or which looks into the area of public finances. These two and other committees are expected to keep an eye on the executive, whether the executive is doing his or her job properly or not, whether there is any discrepancies in their work or not. This need to be seen by the committee specially made for that purpose. So they ensure an effective and comprehensive examination of all the proposed policies. Often, the committees provide an ideal context for discussing controversial and sensitive matters in impartial manner away from the glare of publicity. So it also helps that, and also they provide a useful forum for the utilization of the experience and ability that may otherwise remain untapped. So they also constitute a valuable training ground for future ministers and the presiding officers. Now let's talk about the state legislature. We were talking about union legislature by now, but now onwards we will be talking about state legislature. So the state legislature consists of the government and the legislative assembly. This is a feature. There we can say that there was a parliament, there was two houses and the president. Here in state legislature there is governor and the legislative assembly. In many aspects, the legislatures are similar to the Parliament of India. However, all state legislatures do not have both houses. So, like in union legislature, we can say that there are two houses, upper house and lower house. But in respect to states, not all states have two houses. Many few have two houses. So, legislative assembly, what are they known as? Legislative assembly, that is known as Vidhan Sabha, and the Legislative Council Vidhan Parishad. The state legislatures which have both houses are known as bicameral, and those which have only one house, that is only Vidhan Sabha, are known as unicameral. Uni means one, bi means two. So unicameral and bicameral. The choice of having unicameral or bicameral legislature was left to the states. So it is the state who decides whether there will be unicameral legislature or bicameral legislature. It depended on the assessment of a state whether it wanted to have both houses or only one. So the principal reason for not having both houses has generally been financial. So because of financial issues, the reason behind having only one houses or both houses, it is the finance which decides. So some states found it difficult to maintain the cost of two houses. They preferred to have only one house of the state legislature. Very few states, like when India was having 29 states, out of 29 there were 7 states which were having two houses or a bicameral legislature. As of 2019, I'm talking about 2019 because later on many things changed. So as of 2019, Andhra Pradesh, Bihar, Karnataka, Maharashtra, Telangana and Uttar Pradesh have legislative councils. In 2019, the Jammu Kashmir was divided into two union territories, Jammu and Kashmir and Ladakh, with the Jammu Kashmir having assembly and Ladakh without it. So that is why we were talking about 2019's status, because after that the Jammu Kashmir was divided into two union territories. One Jammu Kashmir which was having an assembly, and the second one is Ladakh which doesn't have. So the legislative assembly of each state is composed of members chosen by direct elections on the basis of universal adult franchise from territorial constituencies. So how the members of the legislative assemblies are elected? It is through direct elections on the basis of adult franchise. The size of the assembly varies from a minimum of 60 to no more than 500. The duration of the legislative assembly is for 5 years. So, the membership of the legislative council shall not be less than 40 but not more than one third of the total membership of the assembly. So, there is a difference between the membership of legislative council and legislative assembly. They varies from each other. The house is composed of partly elected. So, now we are talking about legislative council. The legislative council is composed of partly elected and partly nominated members. Normally, one sixth of the total members are nominated by the governor, and the rest are indirectly elected on a complicated formula involving graduates, educators, and members of the assembly. So, the composition of the legislative council is quite complicated. So the role of legislative councils where they exist, in states where they exist, are considered as weaker than the legislative assemblies compared with the status of the Council of States vis-a-vis the House of the People. So it is believed that the legislative council are weaker in their position in respect to legislative assembly. So the legislative council may be considered as unnecessary due to some reasons. So many states feel that there is no need of a legislative council, and what are these issues or what are these reasons? Let's talk about it. So the first reason is the very nature of the composition of the legislative council makes its imposition weak, being partly elected, partly nominated, and representing various interests. So, because of its composition, the Legislative Council becomes weak in front of Legislative Assembly. Its survival depends on the will of the Assembly. So, whether it will survive or not, it is dependent on the will of the Assembly, as the latter has the power to abolish the second chamber by passing a resolution. So, if a state legislative assembly wanted to dissolve or wanted to abolish the second chamber, that is legislative council, it can pass a resolution. So, the fate of the legislative council remains in the hand of the members of the legislative assembly. So, the council of ministers is responsible only to the assembly. The council's position is very weak, for it can only delay its passage for a limited period. Hence, the second chamber of the state legislature is not a revising body but a mere dilatory body. So, the legislative process in the state assembly is similar to that in the parliament, with one significant exception. The governor can reserve any bill passed by the state legislature for the consideration of the president. So this was all about legislature. Now we will be moving towards Unit 8, and we will be doing only one part of Unit 8 today. I will be continuing with Unit 8 Executive in our next session as well, in which I will be talking about not only executive but judicial. So let's talk about executive. The executive power of the government of India is vested in the President of India, who is both the formal head of the state and the symbol of the nation. So, the executive power of the government of India is vested in President, and he is considered to be the formal head of the state and also the symbol of the nation. The Constitution of India, however, bestows authority and dignity on the office of the president without providing adequate powers to the rule. So, there is a dignity and authority in the office of the president, but it doesn't have that much powers to rule. So, the president performs essentially a ceremonial role. So, in a parliamentary system, the role of the president is quite ceremonial in nature. The prime minister exercises real executive power. So, in a parliamentary form of government, the real executive power lies with the prime minister. While the president is the head of the state, the prime minister is head of the government. As we can see, in a parliamentary form of government, it is the prime minister who is the real executive, and he or she is known as the head of the government, whereas the president is known as head of the state. The president carries out the actual functions of the government only with the aid and advice of the prime minister. So, whatever a president is doing or functioning or doing his or her job, it should be with the aid and advice of the prime minister. So let's talk about President of India. The president is a ceremonial head, as we already discussed, and that he does not arrogate to himself any real power. The president is indirectly elected for a term of 5 years. So the tenure of the president is for 5 years, and he or she can be removed on the basis of an impeachment proceedings that should be brought against by the parliament. So the impeachment proceedings are done by the parliament against the president. So the constitution also provides for the post of a vice president. He or she is also indirectly elected, who would serve as the head of the state in the event of president's resignation, removal by impeachment or death. Let's talk about the qualifications of the President of India. Articles 58 and 59 of the Constitution of India lay down the qualifications for the office of the President of India. So, whatever the qualifications required for a president to become a President of India, all these things are mentioned in the Article 58 and 59 of our Indian Constitution. So, a candidate for the office of the President should be a citizen of India. This is one of the major criteria to become a president, must have completed 35 years of age and possess other qualifications which are necessary to become a member of the Lok Sabha. So he or she should not hold any office of profit under the union, state or local governments at the time of his election, nor should he or she be a member of either house of the parliament or state legislature. So, a president is not allowed to be a member of either house of the parliament or state legislature, and he or she should not hold any office of profit under the union, state, or the local governments during the time of his or her election. Let's talk about the method of election, how presidents are elected. So the constitution prescribes an indirect election through an electoral college. So the elections of the president is done through an electoral college. And now let's see what this electoral college is composed of. So the electoral college, which elects the president of India, composed of the elected members of the parliament first. The second thing is to the elected members of the state legislative assemblies. So who are the part of this electoral college which decides who will be the president? It is the elected members of the parliaments and elected members of the state legislative assemblies. Here we should know, or we should understand, that it is written elected members. That means all the nominated members are not allowed to vote in the presidential election. So it should be remembered by all the students that the electoral college consists of only the elected members of the parliament and the elected members of the state legislative assemblies, and not the nominated one, on the basis of the proportional representation and by the means of a single transferable vote system. Based on the system of principles of uniformity among states and parity between the center and the states, the election procedure is designed to ensure the election of a truly national candidate. So this is the method of elections. Now, voting is done by the single transferable vote, with electors casting first and second preferences. So there are preferences given. On the basis of that, single transferable vote system is there to ensure the election methods. So the candidate who receives an absolute majority of votes cast by the electoral college is declared the winner. So the method of election was intended to make the presidential elections a broad-based, to achieve a political balance between the center and the states, because both the member of the legislative assemblies and the member of the parliaments were participating in the elections of the president of India. So there is also few terms of office and how a president is removed from his or her position. So the tenure of the office of the president is 5 years. Article 56 and 61 deal with the procedure for impeaching the president of India. So in the Constitution of India, there are articles 56 and 61 which talks about how will be the procedure to impeach the president. So the Constitution lays down violation of the Constitution as the ground for removal. So, if a president violates the constitution, then there will be a ground to remove that president or impeach that. So, the process of impeachment can be initiated in either house of the parliament and must be passed by not less than two-thirds of the total membership of the house in which it has been moved. So, the impeachment process is also very interesting to understand because it can be initiated in any house of the parliament, whether it's upper house or lower house, and it should be passed. The impeachment process should be passed by not less than two-thirds of the total members of the house in which it has been moved. So the procedure of removal of the president is difficult and has been made so to prevent the misuse of this power by the parliament. So to not to not allow the parliament to misuse this power, that is why the removal of the president's procedure is very difficult. Till date, no president of India has been impeached. So, this is all about what we have talked today, that is legislature and executive. In our today's lecture, we talked about how the legislature, how the parliament works, what are the components of the legislature. For example, there is two houses, Lok Sabha, Rajya Sabha. We talked about that, how it functions, what are the powers, what are the functions it play. Also, we understood that how the role of the president is very important. He or she, the president, has many special powers with it. Not only president has special powers, but Rajya Sabha also has special powers, which allows it to play a very important and essential role in the legislative process. So it is in a parliamentary system of government, we can say that it is the legislature and the executive which works together, whereas in a presidential form, which is found in countries like America, there is Sri Lanka. In these countries where there is presidential form, the work done by the legislature and the executive are totally different, totally separate. They don't allow one member of, for example, if a person is member of a legislature, he or she cannot be the member of the executive. Whereas in a parliamentary form of government, we could see that the executive is decided by the legislature. So legislature has power to create the executive, and executive is accountable in front of the legislature because it is the legislature who created the executive. So legislature and executive in a parliamentary form of government works together. It is not separate from each other. They works together. The legislation is made in the legislature, and also the executive consists of president, prime minister, cabinet ministers. They are also part of the legislative process and they work together. So this is a very special feature of parliamentary form of government. And also remember that we inherited this parliamentary form of government from Britain because we were colonized under the British colonial government, and from there only we inherited this parliamentary form of government, whereas many other countries have presidential form of government where the president is the head of the state. Here also, the president is head of the state, but the real executive power lies with the prime minister, and he or she, the prime minister, is known as the head of the government. So the government is accountable in front of legislature because it is related to that, and legislature decides about the executive. So we learnt about this. Later on in unit 8 we talked about executive, and here we talks about the president, how president is elected, what is the method of elections, how the president is removed or impeached, and what are the roles played by the president in our country. So this is all about today's class. In our next class, we will be continuing with unit 8, that is executive. In that, we will be talking about the powers of the president, the prime minister, because prime minister is the real executive of our country, and all the powers, all the executive powers lies with the prime minister in a parliamentary form of government. So it is a very important topic which we will be covering in our next session. So, in the next class, we will be talking about powers of the president, prime minister, and what are their powers, how prime minister is elected, what is the methods of election, what are the roles and functions of prime minister, the cabinet. We will be also talking about the cabinet and the parliament, and we will move on to unit 9, that is judiciary. So, thank you.